We have sound. Amazing. Thank you very much. I appreciate that a great deal. Thank you for letting me know. I would have just sat there and talked to the mic the whole time like a fool. Do we have a question? Is there something I can help with? Everyone, please remember to like the stream. It helps us a whole bunch, I am told. I know. I really would have talked to that mic for like an hour and just been like, you guys are quiet today. I don't know. Am I doing something wrong? It's just not folding right. There we go. Maybe, I guess. If you don't ask a question, I'm going to start telling stories. Hi, Jimmy. All right. If we don't have questions, I'm going to start with a story to kill time till people show up. I got in my first fist fight in quite a while. We do have a question. Okay, so I'm going to leave that one hanging. What's Jimmy, whose last name might be included in that, which I will leave out, says, what is a better settlement, state or federal court? So are you asking which one is likely to drive settlement? Like if you file in state court or federal court, is that the question? Hey, Eagle. Hey, Nolan. So, Jimmy, it depends a little bit on where you are. Normally, I would say federal court. In most of the country, like 95% of the country, I would say federal court will drive settlement better because you can bring the state, the federal, and the local claims all in one action. And defense attorneys who work in federal court tend to be a little more expensive. But in certain areas, the jury pool can be really good. Like if I have a case in the Bronx in New York, I'm not perhaps necessarily as interested in federal court unless there's a specific reason why I want the federal laws, because the Bronx jury tends historically to be kind of aggressive towards employers. And in settlement conferences, you kind of just be like, Bronx jury says what? Like, what are you going to do? You're going to litigate this in the Bronx? You're not. You're not. We all know you're not. You're going to settle, right? So it depends a little bit. In Ohio, I would generally, and check with local counsel, Jimmy, but in Ohio, generally, I want federal court. Noland, I will tell the story later. I did not whoop anyone, but he did run away. Rashawn, we have an entire playlist on this channel about calculating damages. I would recommend that you hit up that playlist. It's going to walk you through a lot of the basics of calculating damages. In reality, we have some fairly complex spreadsheets that we plug data into, and then we tweak that based on additional characteristics of the case, the situation, the public narrative. You know, there's a lot of leverage in these cases. A lot of things. There's a lot of moving pieces to think about, Rashawn. Jamal, how you doing? I've been approved by the EEOC to sue Benjamin Moore Paint. How do I find a lawyer that will take my case and get paid after we win? Jamal, I would recommend you use our How to Find an Attorney playlist, which seems like that seems like an obnoxious response for me, but we made like 30 videos about how to find an attorney, and we have a whole nother playlist about how to pick the best one. And in those two playlists, I put a lot of time and effort in. It's all free. I'm not trying to sell you anything, right? Like these are free videos to try to help people not hire us, essentially. And I think those two things are the best things in terms of finding and choosing an attorney. Cesar asked us, I'm assuming there's vowels in there, CZR. In California, wage and hour statute of limitations is 3 years. I'm not allowed to comment upon the state laws of California. I can only comment upon the federal laws in California. Can't. Nope. You're asking me a state law question. I'm not allowed to answer that, CZR. I'm sorry. I can answer under the federal laws, but I can't answer state law questions in most states. And all the attorneys in my firm who can refuse to create videos. New York. Is that East New York? I like East New York. What happens if an investigator at the New York City Commission on Human Rights leaves after investigating for a year and my case gets reassigned to someone new? When can I ask for an update? Whenever you want. Whenever you want, East New York, New York, you could ask for an update. Just do it nicely. Don't rile up the investigators. They can turn on you. If you can recruit them to your side, that is better than ruffling their feathers. Oh, Jimmy, okay. Jimmy, I think we made you a video this week where you didn't want to pay attorneys 40%. If you can find a good attorney and you think they're going to produce you more than 40% in terms of a better result, I think that 40% does not bother me one bit. Nolan, are FMLA violation claims worth it for employment law attorneys? Always depends. So I bring plenty of FMLA cases. I bring a lot more Family Medical Leave Act cases under the federal law than I do like a New York paid family leave case. The New York paid family leave is like a neutered statute. They mess with the New York statute really bad to make sure that people couldn't get representation essentially. But yeah, so it depends on, listen, if the negative workplace consequence is bad enough, if you've been through enough, if they've harmed you enough, a Family Medical Leave Act claim can absolutely be valuable and absolutely can be worth it. Hello, Ryan. Eagle 97 asked us, can a rebuttal in a workplace discrimination complaint with the EEOC or state agencies serve as a guide for the investigator as far as who to interview as a witness or which documents to request? Yes, Eagle. So that's actually the key. You're on to the key. Like, you have a future as an employment attorney. If you can do the investigator's job for them in your initial filing and in your rebuttal, that is the best. Like, if they can just say, hey, I'm going to adopt what that person said in the rebuttal as my plan for action here, that's amazing. It's going to get you a better result. Generally speaking, it's a huge advantage. Rashawn, I'm really glad to hear you figured out how to use Pacer. It is a hassle, without a doubt. Nolan, I think I already answered that question. Did I? Is there something new there? Wrongful and repeated. Okay. So Nolan, spelt cleverly, no land, asks again, are FMLA violation claims worth it for employment law attorneys? For instance, he adds, obviously wrongful and repeated denials of leave for not enough hours worked when I had actually worked over the required number of hours. Yes. So it depends. Again, the answer is pretty much the same. If they're messing with you and it's willful and it's repeated, that's going to be an aggravating factor that could add some value, right? Because it could really cause you a lot of emotional frustration. And I don't know what you're trying to use FMLA for, if it's for your health, it's for family member, whatever it is. But the idea that you're trying to like get treatment or take care of a family member and they're just trying to mess with your FMLA, that in and of itself could be enough. But generally, you are going to want to see, for more valuable claims, some negative workplace consequences like losing promotions, bad evaluations, losing hours, losing money, termination. There's a lot of things, right? That would generally make it better. Jamal, and I'm happy. Like, listen, I'm sorry that I told you to check out the playlist because I feel like I should have answers for you here, but the playlists, I spent hours on the playlist. So like it is a great first stop. And then if you have follow-up questions, I will keep an eye out for your name to give you follow-up answers. Brown-eyed girl asked, what are some of the things that employees do that destroys their case against the employer for employment discrimination and retaliation for a covered health condition? Brown-eyed girl, great name, great song. A lot of employees will not document or will lose their cool and do something like take a swing or say something wild or, make a death threat. Like that's how we see stuff like that. Or we see some grosser stuff. People do funny things when they get frustrated. That destroys claims. Also in depositions, you'll get people get a little bit excited and they don't need to lie for their case, but they think they're trying to do more and more. And they'll say things that aren't true. And then I got to pull them out and be like, hey, buddy, we're lying under oath. Got to go tell the truth. And that can destroy a claim real quick. Listen, you can rehabilitate that. You can fix that. But you got to just go back in and be like, I messed up. Like, just own it immediately. Don't be in like a shoving match with me in the bathroom where I'm like, you're lying under oath. I cannot suborn perjury. You need to go back in there and tell the truth. You don't need to lie. You're in this incredible position where all you have to do is tell the truth. So just go in there and tell the truth. And people will be like, nope, not going to do it. It's like, we're done here. Like, I'm not giving up my license because you're an asshole. I want to help, but nah, right? Hello, 1222.9. You can post them on one of the YouTube comment threads on one of the videos. So hello, you gotta post the questions publicly so I can answer them. And if you post them publicly, I will get a notification. And sometimes I see them. Sometimes people from the channel will comment underneath them. Like if I see, especially some of the more popular viewers, like we have a couple. Well, it's not a couple anymore. There's about 50 people who are pretty much regulars on the channel who will try to answer questions and talk about stuff. And often if they're talking on your thread, I'll see more and I'll be more likely to see it, be more likely to answer it. Also, we have a couple people at the firm who will highlight questions for me. So yeah, just post it on a video and I will try to get you an answer. Nolan, I hope your son is okay. That really sucks and I'm really sorry. Laura asked, she has two questions. Why will an attorney not file a Section 1981 on a racial discrimination case? And why would an attorney start by demanding for a severance agreement? So, Laura, 1981 is a complex thing, as is 1983. They are, I think I'm guessing I know why you want 1981. You believe that 1981 doesn't have a cap. Is that your logic as to why you want to sue under 1981 instead of like Title VII or whatever it is? I'm going to assume it is because I think chat is delayed. Generally speaking, if you go onto federal court and you're actually in federal court, not the EEOC, but you're actually in federal court, and there's a viable 81 or a 1983 claim, I do mix it in. I do think that's a good idea. A lot of other attorneys won't, because it creates a huge amount of extra work for somewhat limited benefit, depending on what state you're in. Because if you're mixing in state and local laws, they may more than make up for any advantage you would have picked up potentially with a 1981 claim. And you can make an argument, depending on where you are, that is right and correct and that you should skip the 1981. I don't love that. And I don't love it specifically because I think it breeds laziness in associates. Like, is that a right thing to do? Is that correct? Yes. If you have advantages under state or local law, that can absolutely be correct. But if you can hand a jury a verdict sheet with more opportunities to give your client money, right? They can have so many different claims on a verdict sheet, right? And if I can add one more by working an extra 10 hours and I'm working on a percentage, right? So if it's hourly, it's a little bit different because you got to tell your client, like, listen, we're going to spend 20, 30 hours. If we add this 1981 claim, we got to add it in. There's other stuff that might come up for motion to dismiss. We might fight it on there. We might have to fight at the summary judgment stage. There's additional arguments and drafting required. It's going to cost you tens of thousands of dollars, right? That's different if it's hourly. But if it's my firm and we're doing it on a percentage, like a contingency, leave no stone unturned. Reduce risk, add value, make the money. The client doesn't have to pay you. So get the fuck out there and earn your money. That's the gig, right? And and a lot of associates will be like, well, but it doesn't give us enough advantage. It's not a good use of my time. And I don't like to be one of these law firm partners who are like, I don't care about your time. You shouldn't have a life. You're a young lawyer. That's all bullshit. But like, do it. If it reduces risk, if it gives you one last opportunity to get a juror to be like, guilty, for the plaintiff, like, yes, do it. So I generally agree with you, even if it doesn't have the advantage you're looking for. The second part of Laura's question is, why would an attorney start by demanding for a severance agreement? So I don't know if it's just a severance agreement or a settlement agreement that they might be arranging for you. Are they leveraging claims? If they're leveraging racial discrimination claims for you, as you kind of mentioned, then the severance agreement probably would not be appropriate unless the employer just prefers calling it a severance for some reason and it's negotiated in the style of a settlement agreement. That would be fine with me. Like, there's certainly cases where we open up, we say, hey, we're gonna come after you the next 10 business days if you don't start making our client offers. And the employer says, well, hold on now. Can I just inquire how many zeros are going to have to be on that check? And generally, my client would say, yeah, you could. You could ask me. I've got a couple answers, got a couple thoughts on that. And if that's what the employer is doing, then I don't care if they're calling it a severance agreement or a settlement agreement. They might want to characterize it as severance, right? So as long as my client's getting paid, I'm generally happy. Eagle 97 asked us, when would an employer realize that more likely than not, an employee's workplace discrimination complaint will result in a probable cause ruling by the EEOC or state agency? Just finished my espresso. I will introduce my co-star very soon. The EEOC, never. They don't care. They don't care about probable cause finding by the EEOC. State agencies are different, and they're very different state to state. And generally, the defense counsel will tell them, like, outright. Like, there's a lot of cases where I'll be talking to defense counsel, and then she's like, listen, we both know this is getting probable cause. Like, you got a trial team on this? Like, what's going on? Like, obviously, you're not paying my client. We're not going to take this nonsense you're offering right now. Who's the trial guy? What are you doing? Like, and those conversations happen. And I presume from those conversations that they're also telling their client, hey, if you don't want to settle this, you are going to pay for a trial. And that trial is going to be over 6 figures in defense costs. And you could still lose, right? So I think that their attorneys go to them, Eagle, and tell them that. New York or East New York, if my witnesses are not contacted and it has been 3 years since the discrimination and retaliation events, what to do if they don't remember? How can an investigator pursue? So this sucks. This is a real issue because you'll get investigators or agencies who sleep on cases sometimes and cases go too long. And realistically speaking, that's going to make witnesses forget things. Often what I do, and I don't know if this is going to help you, is we'll proactively reach out to witnesses and get them to engage, like sign affidavits with us. Like, hey, tell us what you saw. Tell us what happened. We're not going to mess. We just write it down and we'll get it as a sworn statement. And then you can use that to refresh the recollection should you need to during the case. I don't know if that's going to help you, East New York. Don't get into a situation where you're trying to help them remember, because that's going to be like a little adjacent to witness tampering, right? Maybe the investigator can help them remember, stuff like that. Hello. 1222.9 says, I settled an employment wage and discrimination suit and mediation a year ago against 2 defendants. That's awesome. I hope you got paid everything you wanted. I hope you were made whole to whatever extent they were capable. Nolan says, this is still the, I'm really sorry. I'm glad your son's okay. Oh, no. Oh, okay. Thank God. Son almost died from liver failure, but is okay now. Thank God. I thought I read that the wrong way, and I was like, oh my God, your son died. I'm really glad your son is okay. Eagle 97 asked us, okay. So Eagle 97 asks us, if the assigned investigator is fresh out of college, but says on his or her LinkedIn profile that she is for social justice, could that help in getting a probable cause ruling? I actually think being fresh out of college has more to do with you potentially getting a favorable ruling from an investigator than the phrase social justice. Social justice is like, it's a little bit like AI in terms of the way people use it now. It's like a catchphrase that people say, like social justice, right? Generally speaking, it doesn't mean a lot. Like, I'll have conversations with people like, I'm for social justice. It's like, okay, great. Like, it's wrong that you charge people. I'm like, okay, I'm sorry you feel that way. You don't help them at all. So I don't know. Like, I'm sorry I made a business helping people, and the business stays alive by charging. Like, charging a percentage of what we win for people, right? You, on the other hand, do fuck all. You don't help them at all. So I guess I'm a bad guy. I don't know, right? But I don't know. Social justice is like a weird tag these days. It is possible. Listen, that sounds good. That it sounds like they might take the investigation seriously. Dwayne asked us, "Hi Vince, I got a no probable cause, but the investigator found that I had evidence that I did complain about sexual harassment when the employer lied in the statement. Should I go to court? Do you have a retaliation claim? So did they do something to you because you complained?" Right. Okay. So first off, I don't know enough about your case, right? That could be a great case, and I am not at all perturbed. Like investigators make mistakes. Like I have seen so many no probable cause findings that made no sense at all. Like it doesn't make me when I see no probable cause, I'm not like, ooh, I'm not into this case. I'm still like, let me see the case. Do you have a right to sue letter? Can you still go to federal court? Because if you can still go to federal court, then I get a chance to take a full on fresh swipe at the case, right? And if you can't listen, if you have no probable cause and you don't have a right to sue letter, you can't. If you don't have the option to get that right to sue letter from the EEOC, then we're in a bad place. We're in a real bad place. But if you have a no probable cause and the case looks good and you get the right to sue letter, and especially if you have that retaliation claim to go with it, I'd be real excited about that potentially. Like that's a case that I might want to get involved in. And I'm not trying to say like you should hire me, but I'm saying generally speaking, attorneys will want to get involved in that. If you got fired and the harasser threatened you and they said you're in a violation of misconduct, yeah, that's a great case. Like that's a fantastic case. That's solid. Those retaliation claims are low risk, lower risk, not low. There's no low risk litigation in this field. It's lower risk, higher value. You open up a third class of damages. You can shift the burden of evidence in the retaliation claims. Like those claims can be so valuable. Those claims can be buy you a farm valuable specifically. Since most of my VIOs have clear paper trail, Nolan, I don't fully understand what you said there. And I don't know what a VIO is in this context. I'm sorry. More questions, people. I'm going to tell a story because I think I'm caught up on questions right now. So until I get another question, I'm going to tell my story. On Monday, the day before Halloween, introducing my co-star, which is actually a present from a viewer. Do not send me presents. This is a very lovely bourbon, I believe, called Angel's Envy, who was sent to me by a wonderful viewer, and it is lovely. Wow, that is lovely. Monday, I was in New York City, day before Halloween, like 6:30 p.m. I was getting off the subway at 59th Street, and a young fella, a young man, who's probably about a head taller than me. I'm not a giant. I'm 5'10" and maybe 50 pounds on me. I would say maybe like 250 pounds. This cat, very loud. I don't know if you can hear that. I was going to get off the subway, and this guy hit me full speed, cracked his head into my face, stumbled back. So I don't know what his deal was. And then his little minion friend slammed into my side. Lady behind me screamed. Dude next to me, like, started saying some shit. Like, I think he might have threw hands at this guy. Like, because everybody's pretty like the door just opened and wham. I'm like, couldn't even seeing stars. No idea what's going on. I'm aware the guy next to me punching out the door, and I just start like, I don't know. I just started swinging like a blind person. Clipped the kid pretty good in the belly. He didn't like that. I don't think that belly was built for punching. He's not strong bell-wise. If you get the Game of Thrones reference, I'll tell you that right now. So the kid like retreats. Him and his buddy both retreat. I think the guy next to me like cleaned up the smaller one pretty good. That was that guy was not having it. And we finally get off the subway. Garage opening up. What's going on around here? we finally we're getting off the subway, and I start walking. Like, that kid had run away. He's probably 20 or something. Um, and then I hear like some guys yelling, "Hey, hey, turn around!" And I turn around, and these two kids are running back at me, and they see me turn around, and they're like, "Nope," and they just went the other way, and I was like, "God damn, this city is a shithole now." Like, I lived there for 15 years. The place is the loony bin now. It's insane. Yeah, it could have been a brawl. It wasn't a brawl. I fully credit the guy next to me who was very clearly like on his toes. Just started going to town on the little one, which was not. I had bigger concerns. The big one was awfully big. I do. It was not Halloween. It was the day before Halloween, but that's enough. You had your dinner. You're fine. You're good. Okay. All right. Right. We got some questions while I told that stupid story. What do we have here? Is the US EEOC focused on prioritizing resources at industries where minorities have been and continue to be historically marginalized, like econ, legal tech, consulting industries? It's a cesspool. Soul Cadence, they say that they are. I don't really presume to know what they actually engage in, but they do say that they target industries with this cat. You can see her ears at the bottom of the screen. They do say they target, industries with historical issues for racism and other forms of discrimination. I don't know too much about legal tech consulting, besides that they're all thieves. I'm joking, not you, I'm sure. I would think finance would be a big, like, I think they'd be really interested in finance. There's so many finance companies um, that have such little diversity, like 8 women in management and no minorities, stuff like that, right? I see a lot of that stuff. So I know the EOC does like to go after them. Also, it depends on who you're dealing with and who's kind of in charge at the EOC at a given time, because some of them will try to launch their career and like take big swings at famous companies. Like, you see a lot of people taking swings at Amazon right now. Part of that's because Amazon's messing up. The other part of that is because that gets headlines, right? Let's see. Dwayne Harper goes on. The investigator said, since I didn't make a formal complaint until after the altercation, they can't be held liable. But I complained months before, which I had proof of when I called the company hotline. And I texted my super, Dwayne, you got to prove. You're going to have to prove that you made that complaint, right? I would definitely do everything you can to prove when you gave your employer notice and made that complaint, because that's your protected activity. Anything bad that happens to you after you engage in that protected activity is going to be presumed to be retaliation. They can beat that presumption, but it will be presumed. Day one of court, they're going to be guilty till proven innocent. Is the best way to think of it, of retaliation. So, Dwayne, prove that you made those complaints. It's going to be a huge help for you. Next question, Alicia said, my lawyer called to talk to me about settling for only $15K and I told her I wanted $40K. I have not heard back from her for over 3 weeks now. What can I expect? Depends on your attorney, right? Did your attorney say why she felt you should accept $15,000? That's always the question. Is there a why, right? If the answer is I want 40% of, or whatever it is, of 15,000, then that might not be a good reason, or whatever it is. But if the attorney's like, listen, here are the risk factors, let's go through them in depth, let's talk about it, I don't think you're going to win as much as you think you're going to win, like, let's talk about this 15 grand, that could have value as a conversation fundamentally. But it's all about the why, right? Eagle 97 asks, how ignorant can an employer's in-house counsel be when facing a workplace discrimination complaint in terms of the entire process? Eagle, they can be entirely ignorant. So different kinds of companies have different kinds of in-house counsel, right? If you're working at an art company or a fashion company, the in-house counsel you have might be focused on IP, intellectual property, trademark, stuff like that, right? If you're a retail establishment, like a big box store, there's a really good chance that your in-house counsel is focused on leases, retail leasing, right? If you're big tech, your in-house counsel is going to have a depth of knowledge about vesting schedules, IPOs, getting rounds of funding in, disclosures, um, roll-up agreements, like big, click wrap agreements, like when you download a video game or software and you have to click to accept it. Like that's what they're going to know about. Like different fields have different kinds of in-house counsels. Now, if you get really big, if you're like Facebook is always trying to hire directors of employment litigation and employment in-house counsel, and that's going to be different. But at smaller companies, you don't get to have an in-house counsel who's a general counsel, and then like somebody like me who's been hired to be like the director of employment litigation, right? That's or someone like Eric Sarver, right? Like there's a lot of companies who would die to hire Eric in to run their response when they get complaints. And Eric's just not into it. Eric has no interest in that. And I mean, I presume I don't know Eric's career path or what he's looking for, but I assume he's been running that firm for a long time. He's very happy. He's probably turned down 1,001 of those offers, right? But if you're at a small company or companies just focused on something else, it's entirely possible an in-house counsel won't know very much about the employment laws. And either they can act out of ignorance or they rely on outside counsel for that sort of thing. Okay. What do we have here? Nina 2003 says, have you had any cases where employment discrimination, retaliation, and termination has caused severe trauma and workers' comp benefits was awarded to cover for long-term medical expenses? Yes. I do not handle workers' compensation cases, but I do refer those cases to a trusted workers' compensation attorney, depending what state we're in. And I have seen that, certainly. Yeah. And mental health and trauma in workers' compensation is a difficult path in most states. But if you have the right attorney, it is very real. It's something that can be done. Alicia asked, she mentioned if I did not want to, this is her attorney wanted her to settle for 15,000. So Alicia is going on here. She mentioned if I did not want to settle, we can take it to trial, but it might take a very long time. And we have until the settlement deadline is until next year in November. Okay. I mean, that might be true. So, I mean, if she's saying, if the conversation is, hey, you can have 15 grand now, or you can wait a year and we can risk everything at trial, I'm fine with that conversation. Like so I assume that she's actually calculated damages. And for whatever reason, she thinks 40,000 or you think 40,000 might be what you could hope to win at trial. I don't know. And if her conversation is, listen, I can get you 15K today. If you want the money today, we can do that. If you don't want 15K today, we can go for the bigger number, or we can go for trial, but that's going to take more than a year. That's a fine conversation to have. That's just your attorney being real with you. As long as all that's honest, I'm fine with that. Soul Cadence asked us, I'm in the DC area. It's very widespread. I most recently came from a mid-sized economic consulting firm with literally 3% AAs in the entire company, and about 1% in management. Thank you. Yeah, I believe that. That sounds like what we tend to turn up in discovery when we get some of that data. So yeah, that tracks for what I know, certainly. If Dwayne asked us, if a state agency issues a no probable cause, does that mean your state claims are gone too if you go to court? Dwayne, in most states, yes. But I can't tell you every state. I'm not allowed. Eagle, bye. Have a great evening. Nolan asked us, for my situation, FMLA violations, then I complained and I'm now sitting duck for dismissal in a 4 or 5 months. You know the deal. I feel like settlement and maybe severance would be good. So Nolan, if you complain, you do have those protections against retaliation. I think you feel that those might be running out. Do you need to exit? I don't think you need to exit because you have those protections. But if you want to exit, that's perfectly reasonable. I would think you could probably easily push those claims into a settlement based on what you've told me so far. If you have the right local counsel. Alicia said, sorry again, but my last question, you don't have to be sorry. This is my job. Right? I'm here to answer your questions. And if I get through all the questions, I have nothing left to do. I'm just going to have to sing a song or something. Your questions help me. So Alicia goes on to ask, would I be able to backtrack and accept the $15K? I figured I'd boost my small business and earn the other amount sooner than if I would be able to go to trial, if I waited to go to trial in 2024. Yeah. So you're taking into account opportunity cost, right? Like, and that's something a lot of clients don't really get their heads around. Like, I'll say to people, like, listen, right now they want to pay you $400K and you want $600K, but the earliest we're going to get our trial in state court is probably 2.5 years out, right? And this is purely a state court situation in New York. So just giving you context of my hypothetical. You can take $400K today, or you can risk everything and go for that extra $200K and get $600K total, which is what we believe you could hope to win. And that's your choice. But if you wait those 2.5 years, you're not going to have the $400,000 right now. And a lot of clients will be like, I don't care. I want that other money. And it's like, yeah, but think about what that $400K could do for you right now, right? Like you're looking at what that $15K could do for your business. And it's tough. Like I don't like pushing clients into settlements, but sometimes you got to be like, hey, your mom's dying. And you've been very clear with me, if you had $70,000, your mom wouldn't die. So are you taking that into account? Right? Like, and those are tough conversations, right? Or much, much, much less tough, much more fun. Hey, you got a business. It's actually going great. If you had that $400,000, you can invest in that business and do phenomenal, right? Do you really want to risk it all and wait 2.5 years to get paid? Like that's the opportunity cost conversation feels to clients like we're scamming them. Like I'm aware of that. I can see it in their eyes. They're like, you're trying to get me to take this money because you don't want to do this trial. It's like, no, I will do better. If I took every case to trial, if this firm took every single case to trial, I would do so much better in aggregate. There's no impetus for me to force someone to settle. Trust me, these lazy ass trial teams need to work. They got to get out there. But that being said, it's often not the right thing for every client, right? So even when you can see it in their eyes, they think you're like trying to like Jedi mind trick them into settlement. You're just like, no, think about not having this money for 2.5 years and what you could do with it if you did. And that's a reality. And our people are going to be stuck on the fact, but then I'll feel like they got away with it. Okay, that's your right. You're the shot caller. You make the decision, But Alicia, I hear what you're saying. I tend to agree with that. Nolan, it's entirely possible if you make a demand pro se on an FMLA claim that you might get something. You will not, in my opinion, get much, or at least not as much as you might have hoped to. New York says, doesn't matter when I put the company on notice for engaging protected activity. Always. Excuse me. If the discrimination begins months prior, but I feared my boss and then told HR months later, it's just kept going. So it matters only in the context of you have protections in place from the moment you complain of discrimination, right? So when you give them notice, hey, this is happening, I'm complaining about it, you have protections that lock into place. And from that moment on, anything negative that happens to you in the workplace can be viewed as retaliation, which can add a third claim, a third pool of damages to your case. Like that's really beneficial. If they do bad things to you before you complain, that's not retaliation because they weren't on notice and they can't be pursued for a retaliation claim. All right, Dwayne asked us, would a big chain company like a retail giant be more inclined to settle a retaliation claim than go to trial? It depends, Dwayne. It really depends. We've talked on live streams about like Walmart before, and like Walmart and UPS are famous for just being like, nah, let's try the case. Let's do it. And you know, but by the same token, you're gonna run into trying to think of the GameStop. Based on my recollection, I've seen an awful lot of GameStop settlements. So, you know, you can extrapolate from that. Maybe GameStop is more settlement prone. Different companies are different ways, right? Hi, Abraham. Okay, here's your question. Abraham asked us, if someone signs a settlement agreement heavily medicated on antidepressants without an attorney, could that settlement be revisited? Maybe. It's going to depend on what your doctor says about the antidepressants and if those antidepressants eroded your ability to have the mens rea, the mental capability to enter into a settlement. It's also going to depend in part on what state and jurisdiction you're in. If the settlement agreement asked you if you're on antidepressants or you're on any kind of medication that could impact your judgment, many of them do. I laugh at defense attorneys who don't include that. Pretty hard. You're also going to run into something like if you're trying to reopen that settlement agreement, how long has it been in place? How long have you had the money in the settlement agreement? What did you do with the money? Right? Like there's a lot of people who will settle a case, take the money, spend the money, and then like 6 months later be like, I'd like to sue again, please. It's like, that's not going to work out. Like I'm not giving you legal advice on this one, but like that's not going to work out, generally speaking. And attorneys are not going to take those most of the time. But yeah, amazing. So it's Abraham says it's fresh, the money's still intact. So you're in the best possible place to revisit that settlement and undo it if your doctor is willing to support your narrative. And I don't mean narrative like it's fake. I just mean like you have this thing you have to prove wherever you are. There's going to be some standard for overturning that settlement saying you didn't have the mental capability, right? And whatever that standard is where you are, if your doctor will say, yep, this person didn't have that capability, then you might be able to get out of that settlement. Keep in mind, though, like if you use those antidepressants every day, you use them for a long time, you drive, you make banking decisions, you enter car loans, you go to your job on those antidepressants, and then all of a sudden you're like, but I couldn't settle a case on those antidepressants. Everyone involved is absolutely going to smell bullshit. Like that's the first thing. And it's not you, right? You're not trying to do anything shady here, but there's so many people who settle their case and then say, but I want more now. And everybody's like, okay, but why? Like you changed your mind because you want more money, or you changed the mind because you did not have the actual mental capability? And people try to come up with little stories, right? But it sounds like you're in a good place. You might have the best possible chance, but it is always an uphill battle to undo a settlement. It is tough in almost any jurisdiction, but possible. Certainly possible. All right, folks, it is 6:43. Do we have any more questions? Oh, Soul Cadence. Yes, this is a great question. Soul Cadence asked us, are you noticing any trends with domestic violence survivors who take short-term disability leave due to medically confirmed PTSD or their disability because of domestic violence and being fired by the employer as retaliation or disability discrimination? So domestic violence victims exist as a protected class in some jurisdictions, but not all. So what you're asking is about domestic violence victims, survivors. I like your term is much better. Domestic violence survivors. That is a much more empowering term, and I appreciate your term there. The extra steps that you're taking there, we were talking about like short-term disability leave or PTSD and disability because of the DV. These are extra steps that are not necessarily required in jurisdictions where being a domestic violence survivor your word, much better, is the protected class. Now, you can still add those additional protected classes and bring those additional claims where you have like a FMLA or short-term disability issue or disability discrimination for the failure to accommodate PTSD, stuff like this, right? Those are additional claims that generally I would say you would mix into a domestic violence discrimination claim. But what you're kind of giving voice to is that these things are necessary as the actual claim in jurisdictions where domestic violence survivor is not a protected class, right? Now, in terms of trends, how do I see a lot of those claims come to me after they've been turned down 10 times. And I don't know why. I don't know why. I don't know why people don't take those claims. I don't know what's wrong with attorneys. Those claims are fantastic narratives. Which is like I'm a monster for saying that. Like, what I'm saying is like a victim of domestic violence has this amazing narrative that can be turned into money for that survivor, right? Which is like nobody wants that. Nobody wants to experience domestic violence and then be like, oh, now I get money. Like, certainly I'm from a family that loved the knockaround game, right? Like that's what trailer park people do. And nobody in their right mind would be like, well, that was a good deal. Glad I got that money later in life, right? That's not a thing. But those cases are valuable because the narrative hangs together and you look at it and you're like, yeah, why would you do this to this person? Like, there's a lot of people. I'll give you a great example, right? Our country, generally, the society in the US hates mental health disabilities, right? Everybody in my family, with the exception of me and my grandfather, basically had a bipolar condition. When I say basically, I mean they were diagnosed, just different extents, right? And people hate bipolar. Like, if you disclose you're bipolar, it's a matter of time until someone says, just because you're disagreeing with them, you're cycling, right? Or you gotta go, you gotta be fired because you're bipolar. Like that's how they feel about it. If you attach a PTSD condition to a veteran, immediately the employer is like, he's gonna shoot the place up. That's how much they hate mental health conditions, right? That's how predisposed to be aggressive towards mental health many people in our society are. But if you say a domestic violence survivor has PTSD, the response from the average Joe on the street is, damn right she does, or he does. How do we help? Right? And that, I don't know why attorneys don't want to work with that, right? You'll go and take the uphill battle of the depression case, which can be a fantastic case, don't get me wrong, but they seem to not be interested in the domestic violence cases, and I don't understand it at all. Like, I don't know if it's laziness, I don't know if it's not understanding, I don't know if it's just not wanting to be personally involved. Like, there's sometimes you want, like, the more clinical cases, like, um, sometimes, like, a simple dick pic. It's like, "This is gross, everybody involved is this is horrible, like, this is bad." But I don't go home at night and, like, linger on it. Like, "That guy was a piece of shit. He got what he got." You know? It's simpler. So sometimes I think maybe the attorneys run out of emotional bandwidth. I don't know what's going on with that, and I've been ranting about this way too long, but yeah, I've noticed that, so it is messy. Yeah, there's something underneath. So also remember that employment attorneys are deeply flawed, right? Um, and I will absolutely say that cases that should be brought don't get brought for a variety of reasons. And that's like the attorneys failing potential clients routinely. Like I see that a lot. I will have fights with people in my own firm who are wonderful, amazing people who don't want to work certain kinds of cases. Not because they don't believe it's discrimination, believe it's real, just because it's like extra work, it's harder, this or that, or more risk. And it's like, that's not the game. And that's not really, it's actually nothing. I should be clear. That's no one currently in my firm. Because I don't think that really jives with our firm. All right, I've got questions. Let's see. Barney asks us, I filed an EEOC complaint, but my employer ignored it and the state agency issued a subpoena. Why do employers do this? And is it because they have a weak defense or hope it goes away? Could be incompetence. Could be they don't know what to do. Excuse me. Could be they can't really afford defense counsel. Could also just be they did the math and they think you're not going to go on a federal court. They just think you're not going to go on a federal court. And so they think if they do nothing, they won't have to face any consequence. Barney, that's the reality of the situation. That's what it could be. Noland says, I cannot find local counsel. I've sent messages to every employment attorney on AVO in my city and surrounding cities. No reply. Every violation is easily provable. Expand your search. Talk to some of the national firms. And this is not a pitch for you to hire me because like, we're expensive, but like Gloria Allred, right? I'm not vouching for any of these operations. I'm not saying anything positive or negative about them, but like Morgan & Morgan is out there. Gloria Allred. There's a couple other national firms, right? They're out there. There's that guy out of SoCal. I forgot his name, but he has a national firm. It's like a one name partner with a bunch of attorneys attached. What do we have? East New York says, what kind of evidence will be used when a certain discrimination happened behind closed doors? It depends. Every case is different. The limitations of evidence, the limitations of what you can prove, what you can use to prove a given thing, the limitation is the human imagination. But there are situations where it's just one person says one thing, the other person says another thing, and you need to make the jury believe you're a person. It can be that simple. Abraham says, Abraham's talking about the settlement agreement that he wanted to get out of. 3 antidepressants plus a sleep aid. The medication was supposed to be to discuss the mediation was supposed to be to discuss my work arrangements, but the attorney said they were there to settle and sever employment. I was caught off guard. Listen, why you're telling me you showed up to a mediation on a sleep aid? I believe you. That's a weird choice, man. It's a weird fucking choice. You can absolutely, if that is true, there's a really good chance you can get a doctor to say that you didn't have the mental capability to enter in that settlement agreement. But I got to be honest with you, the minute you make that argument, the judge is going to be like, tell me more. How about you showed up to a mediation on a sleep aid? Like that's a rough argument. You're going to have to think of how you're going to deal with that. Right. And I'm not being negative here. I want you to get what you want. Right. I'm just telling you, like if I was sitting as an arbitrator, which I do from time to time, and you came into me and you said, I want out of my settlement agreement because I took sleep aids before my mediation, my response would be, why would you do that? Right? That's going to be a narrative that you need to deal with. Jamal, yes. Let me read your question. Do attorneys take EEOC contingency cases often? Yes. It depends on where you are. Different jurisdictions have different situations. Abraham, I'm sorry if I offended you. I was just trying to point out the issues that you were going to have to deal with. Okay. I'm not saying I doubt you in any way. I'm just saying that those are going to be, you got to think about those in advance. Okay. Jamal, back to your question, which was, do attorneys take EEOC contingency cases often? Yes, but it depends where you are. Like there are parts of the country where never, and there are parts of the country where all the time, forever and always. Like that's how it works where you are. So it depends. Like in New York City, maybe there's like 2 firms who still do that I might be aware of. But it's a little bit rare in New York. Nolan, if you contacted us, I can check on it for you. Our intake people are usually pretty on top of things. I don't know why they wouldn't get back to you, but if you want to contact us again, like if you want to call our firm administrator, 646-661-7233. and her name is Victoria. Leave her a voicemail, discuss your case. She'll get back to you. I don't want you left hanging. I don't know if there's some reason why they didn't get back to you, Nolan, but perhaps there is some issue. Yeah, I don't know, Nolan. I don't know why we wouldn't have gotten back to you. I'm usually pretty upfront if I don't want a case, or even just the intake people. Like, I'm pretty on top of the intake people to let people know, like, hey, we don't want this case. Go find someone else, because then you go find someone else, right? Like, I'm not shy about, like, yeah, I'm not gonna put my money behind this. Like, I think you have a case, but like, you're not getting me to invest 20 to 40 grand or 80 grand, whatever it is in this case, right? I'm pretty open about that. Alicia said she mentioned they would have to pay out of pocket because insurance on covers 1099. Oh, okay. So they weren't insured. Yeah, that makes sense. Most employers are not insured for these kind of claims. Barney says, do employers comply or ignore subpoenas you've observed? Depends on who they come from a little bit. Barney, a subpoena from a state court judge or a federal judge, I would not recommend any employer ignore that, because that is a great way to end up in jail. But if they receive a subpoena from the EEOC, they could roll the dice and just say the EEOC generally doesn't do very much and might not take enforcement action if they ignore them. That's entirely possible. Barney goes on to ask, what are the consequences? Depends on who issued the subpoena. Depends on the enforcement wing of that organization, right? If it's a state or a federal court judge in most jurisdictions of the U.S., the consequences could be fines, sanctions, penalties, and incarceration. Certainly. Jamal, I do not know the vibe of contingency for EEOC in Maryland. I have a friend in Maryland who recently brought her own case there, and I want to say she was not thrilled with her options. But I don't know why or what was going on. That's my fullness of knowledge about Maryland's full contingency options. Dakota Denali, which is one of the greatest names of all time. My God, what a great name. I have a friend who was sexually assaulted by her boss. That is less great. But she's either close to deadline for close to the deadline for filing EOC claims. What are some examples of where someone can get an extension for filing claims? There is not. There's not an extension. Realistically speaking, listen, that's not entirely true. Like, if there's like a capacity reason, like your mental health or something like that, you might theoretically get an extension. So let me tell you, in theory, there could be extensions. In reality, it's not going to happen. It doesn't matter. You just need to get something filed, file anything, and then amend it. But get something filed within the statute of limitations. Also, don't sleep on your state and local claims. For her, like, I'm assuming it's her, I don't know. Those can have longer statute of limitations, and they can have sometimes even advantages over the federal claims. So, don't think that she's like running out of time. How close is it? Like, how close are we talking? What's the holdup? Is she looking for counsel? Is she trying to get her thoughts down? That can be very trying and traumatic. I know that, like getting it down on paper. What's the issue, Dakota? Yeah, I get it. You're trying to find support for a friend. I really respect that. I am super supportive of what you're doing. And I'm going to take a note for us to track your name on the YouTube comments. If you have follow-up questions for your friend, you want to give me some specificity, talk about like what the holdup is or whatever that is. I always try to prioritize your questions because it seems like you're really a good friend, and also you have a great username. Jose Martinez says, I need help with my Jeffrey Epstein case in California. It's going to depend what the case is for. If you were sexually assaulted or human trafficked or something like that. Probably not really our wheelhouse, but I'm also kind of eager to help you. I don't think we can in California though. Wheelhouse, but I'm also kind of eager to help you. I don't think we can in California though, because that wouldn't fall under the purview of the EEOC. So I think we'd be limited out of that. So I think I have to say no. I think I'm required by law to say no, Jose Martinez. But certainly, I think we can all agree that Mr. Epstein did not kill himself. And he was a really bad guy, but he didn't kill himself. Alicia asked us, if they have to pay out of pocket and they're not insured, how long does it usually take to actually receive the funds? Usually about 28 days from when you settle. In my experience, that does differ from state to state because some states have different waiting periods and stuff like that. But generally, in my experience, about 28 days. West Philly Lowlife. So it's W period Philly LO dash life. So I'm just extrapolating that you say West Philly Lowlife, which is a cool name. Supervisor called the cops on me for no reason at all. I have the police report. Never told the cops that I work for a company as an auditor, and described me as a large black. Wow, described me as a large black man trespassing. I would say that your supervisor tried to kill you, West Philly. That is a really good way, especially in Philly, not to shit on your town, to get a black man killed. And I would say that is absolutely a claim. You should be speaking with local counsel immediately. That sounds like attempted murder to me. Kayla 585, I apologize. Is the sound okay? Is it getting better? Ooh. Are we doing better? Uh-oh. Is the sound gone? Okay. Okay, good. All right. Relentlessly Rise said, you helped me out last week regarding my concerns about the current arrangement I had with my attorney. I was paying a reduced hourly rate and a 15% contingency. I actually reread the agreement and reached out. Relentlessly Rise, I'm really glad. I'm really glad. Barney asked, have you seen managers get fired for creating company liability after settlement and trial is over? Yeah, actually, often the managers get fired after the settlement, which is very galling after settlement or trial. It bothers the plaintiffs a lot that the company keeps the manager around while the case is open, but they have to keep the manager around because they need that person as a witness potentially. So that's one of the reasons why they keep them around. What do we have here? Okay, Dakota Denali says, I'm not 100% certain, but I know she mentioned ongoing stalking from the perpetrator, so I imagine that creates some reluctance to go on. Yeah, I agree completely. I get it. It seems like we're having a lot of trouble with the sound here, people. I'm going to call it because I don't want to be like fading in and out. It doesn't make sense if I'm getting questions that are all choppy. I got to figure out what's going on. Like it's a good sound card. It's a good expensive microphone. I don't know what the deal is, but I'll see what I can do. Have a great weekend, everybody. I hope this was helpful in some way. Oh, thank you, Abraham. Okay, Nolan, did you leave a message right now? I will. Oh, you left a message for Victoria. Amazing. Okay, wonderful. Oh, good. Okay. If audio is clear, I'll take one more question. Like I don't want to run out, and y'all. I'm gonna go get myself some Mexican food. It's gonna be amazing. I'm very excited. Get me some molcajete. Lightwork 20. Is that a reference to the famous bodybuilder who used to say light work? I love that. How does previous history of sexual harassment with the same employer factor in as evidence? It can. it can be useful. It's gonna be a lot more useful if you have the same bad actors implicated again. Generally, that's the biggest factor in how that might be useful, but it um, could be useful evidence. Jamal asked us, I haven't watched the playlist yet. But contingency lawyer can still charge an hourly fee. Jamal, I generally don't like to see an attorney working on a contingency charge an hourly fee. So you can work out whatever deal you want with your attorney, right? You can agree like they can charge you hourly plus 50% in some jurisdictions, right? Which is wild to me. That would instantly make me very uncomfortable. But generally I would say to you, like, if someone's charging hourly plus a contingency, what makes me uncomfortable about that is they get paid twice in full, right? Like they get all their time paid for, the entirety, all the way through the case, which could end up being tens of thousands or more. But in addition to that, they also get a percentage on the back end. So like if you're hiring a firm where they're just charging a contingency or they're charging like a flat rate plus a contingency, something like that, they're at least shouldering some of the risk for you. Like hopefully they're covering your expenses and they're putting time in, they're not charging you for labor. So they're pouring money and time and effort into your case. And they're probably not going to end up ahead unless they win or settle your case, right? Um, and you can see what relentlessly Rye is posting. He's saying he or she is saying they already put 300,000 into the case, and that like hurts my soul, right? Because if relentlessly Rye is pouring 300,000 into that case, why would the attorney get something on the back end? Like the attorney didn't have to run any risk. The attorney gets paid every time she or he does work, right? Um, so that's why it makes me uncomfortable. Oh, West Philly. Oh, West Philly. LO dash life. I'm sorry. I misunderstood your name. I thought I thought it was really clever though. I'm sorry. Um okay. As long as you're happy, Rye, I'm happy. All right, everybody. I think that's all the questions. I'm gonna call it a night. Have a great weekend. I'm gonna go get a molcajete and enjoy the ever living everything out of it. And be safe. Be good. Be good to each other. Like, subscribe, comment down below. It helps me to help more people just like you.